self-determination is the way the current UN conventions are developed, the most fundamental human right. It's in the preamble and Articles 1 and 2 of the ICCPR, or the International Covenant on International and Political Rights. It seems like a political right. Self-determination, some would say, is a political right. It is the most legal right in its nature. It is developed through not only the 1966 Covenant, but it's developed in the case law of the International Court of Justice. And the International Court of Justice established very shortly after the 1966 Covenant was adopted, it established that the right to self-determination is Kogan's rule, a peremptory norm, which applies to everyone, everywhere, and as a consequence of having this particularly high status, it gives duties. It puts duties on states to act to promote its observance. And, well, that's one starting point. And then we have the international law decisions relating to Western Sahara. And first of all, we have the 1975 ICJ advisory opinion. What is that? Well, it was a request by the General Assembly to the International Court of Justice to determine legal issues relating to Western Sahara. And for those who have followed that case, it's like a novel. It starts off by Morocco using this request as a reason to postpone its observance with the General Assembly and Security Council resolutions. Obviously, from the point of view of Western Sahara, not a good thing. Morocco was able to use this process. But the moment the opinion is there, and you have to read the opinion, it is clearly establishing the rights of the Sahrawi people to self-determination. And it says Western Sahara was not a terra nullius which countries, as Morocco, could occupy. To the contrary, there were people living there, and they had rights. They had, primarily, the right to self-determination. Now, we know how international law sometimes is not observed. We have other processes relating to other countries. Exactly now, we have just had a conclusion of the advisory opinion proceedings relating to Palestine, where many states made very clear that UN law, UN Charter law, the most basic international constitutional law, if you like, establishes that you can't occupy and annex. You can't grow your territory by occupation. And country after country made this clear in a way it actually has not been made clear before in any of these international proceedings. And we wait for that judgment, of course. That sets the scene when it comes to another very important aspect of the legal status of Western Sahara. And it'd be interesting to read when the decision comes out. Well, what are these advisory opinions? If you look up the Wikipedia or the standard text, they would say, oh, they are advisory opinions and as such not binding. Well, any international lawyer will say, actually, they are very binding. They are binding on what they pronounce on international law. When the International Court of Justice says, here is self-determination, Here are the implications for Western Sahara. Well, that is binding. That's clearly binding because it determines what international law requires. And a country like Morocco and the world is bound by international law, which then has been authoritatively established. We have other important court decisions. There are in this world many opportunistic decisions and compromises made, and I'm afraid to say that the European Union has then entered into agreements with Morocco which belong to that category, which did not observe international law. And this is an area where the European Court of Justice has had an important role because it has invalidated agreements between the European Union and Morocco because the agreements violate international law. And there's a last round, a new process ongoing where we are awaiting the Advocate General's opinion, I think later this month or beginning of next month, and we'll have a court judgment later this year. So there are a number of developments which are important in establishing, or these are not decisions establishing, these are decisions restating the international law obligations, and by doing that, clarify. We are here during a session of the Human Rights Council, the United Nations Human Rights Council. The Human Rights Council is assisted by a number of procedures which deal with different human rights areas. And one of these procedures is the Working Group on Arbitrary Detention. And the Working Group on Arbitrary Detention has, since, it is now a long time ago, it is 15 years, have established and clarified through a number of opinions that Morocco is in violation of international law and international human rights law in its treatment of Sahrawi prisoners who have been arbitrarily detained, tortured, subjected to sham trials where the courts have not subjected the prosecution to the scrutiny it should be subjected to. And this has been done not in one decision, not in two decisions, but a series of decisions over an extended period of time. And they have made findings of fact and of law, and they come with these extremely clear conclusions. And now you can say that's one procedure, that's one specialist procedure under the Human Rights Council. But no, there's a series of other procedures. There's a number of other special rapporteurs who, in their fields of expertise, have made similar determinations of fact and law and about systematic human rights violations by Morocco. I had, as Tone mentioned, I was the chair rapporteur of the Working Group on Arbitrary Detention, and we had a country visit in 2013. And I then had the opportunity to meet a number of the Gdeim Izik prisoners in the prison they were held at that time. And it was an atmosphere of violence and fear, and very in this working group we have the world as our jurisdiction, and as you can expect, there's much arbitrary detention in this world. One gets used to going to prisons, one gets used to see different conditions and terrible violations. Morocco was in a very particular position. The atmosphere of violence and fear, as I mentioned, was something I hadn't experienced before. And the concern is that very shortly afterwards we had this visit, there hasn't been any visits to these prisoners by embassies or by UN special procedures. The working group was the last of the Human Rights Council special procedures which was allowed to visit prisoners. And at the time, a number of the embassies from representing different countries in Rabat, they also went and visited prisoners. That has all come to a stop. Now, our fear is that the conditions, we expect, and we have some basis for saying that we know that the conditions are worsening. They are getting worse than they were when we in 2013 made these findings. Now, it is horrible to think about a group of men sitting in prison for all these years as a consequence of unlawful arbitrary detention. But the conditions under which they are serving those prison sentences, which are unlawful under international law, are worsening. And that's one reason then for going to the States and saying, now, you have these general starting points in international law, which are clear, and you have these findings by these UN bodies, which has built up a very clear jurisprudence with findings of fact and law over this long period of time. This is not any uncertainties. There are no uncertainties as to the systematic and systemic violations of Morocco. That's clear. There's no uncertainty as to Morocco's lack of compliance with these rulings by different UN bodies. And the UN bodies have looked very narrowly at human rights violations. They look very narrowly and in a traditional way, and that also goes for my work in the UN Working Group on Arbitrary Detention. We looked at, are the procedural guarantees observed? Have the prisoners been tortured? Have they been able to challenge in court their confessions, which they gave under torture? And we said no, no, and no. What we did not look into was the extent to which this is linked to the right to self-determination. The right to self-determination as the most fundamental human right at the front of the International Covenant from 1966, the preamble and Articles 1 and 2, aggravate these breaches. This is happening in the breach not only of Article 19 rights, freedom of expression, other fundamental rights, but these breaches also happen, and in particular, in order to promote systemic breaches on the right to self-determination. That aggravates the findings of these UN bodies. So for the fact that you have a Jus Cogens peremptory norm at the top here, that is something which should urge countries to act even more in light of this systematic jurisprudence of these different UN bodies. And it's important to draw that link, the link between these different traditional civil and political rights violations and the right to self-determination. Thank you.
Thank you so